All right, everybody. Well, hey, we are back from our short break. We are lucky to have our buddy Shawn Yesner from the Yesner Law Firm down in Florida join us today on a Saturday. Shawn is just an amazing attorney who has been worked on both sides of the note side for the banks and then also working for the borrowers out here. So Shawn was one of the first speakers that reached out to us when we saw what we were doing it. And I'm like, heck yeah, let's get you on this thing. And excited for what Shawn's going to go through with you guys today. Very, very knowledgeable, straight shooter, and fellow podcaster as well. He's got an amazing podcast called the Crushing Debt Podcast. Got a great book out too, Crushing Debt as well. Hopefully he offers up how to be able to download or grab a copy of this because it's phenomenal information. But good morning from Tampa, Mr. Shawn Yesner.
Yeah, thank you. I appreciate the opportunity.
Hey, no problem, brother. So you've got your PowerPoint. So if you'll see on the bottom part of your control panel for Zoom where it says share.
Share, yeah.
So hit share, and it should pop up a screen. It shows different things you have open on your computer, including your PowerPoint.
Aha.
So click on your PowerPoint then.
Yep, hang on. Stand by. Switching stuff around. Give me 2 seconds.
All right.
And get rid of that, and go there, and go there, and go there, and go there. How's that?
See, Shawn has started, and then yeah, perfect. You just got to put it in presentation mode.
Haha. Okay, so
there you go. Perfect. Look at you. See, I told you it was easy.
Yeah, so I'm gonna quit my business as an attorney, stop being a podcaster, and I'm gonna start doing PowerPoint, Zoom presentations for everyone.
Hit the presentation mode one more time so we don't see your notes on the left hand side. So it makes it maximize the screen. Click there.
You know what it may be? Hang on.
You've got what, 2 screens open?
I've got 2 screens, so I got to figure out which screen it's on.
Yeah, just drag it over.
Go. Yeah. Come on, Zoom. Work with me here, buddy. Why is it not?
If you see it open on another screen, if you just drag that presentation over.
Yeah, it's not letting me drag. It's going through the presentation. So.
Okay, well then we'll just do it with the stuff on the side. It's totally fine. So.
That's okay. What I can do, let me do this. Bang. And yeah, I know. And oh, here it is. New share. Do that. New share. New share. Screen 1. How's that?
I think you'd be better off doing the other way because this is half the screen showing your next slide. So, So just go back and just go back to the previous thing.
Yeah, right.
Do you see the settings thing at the top of the?
Yeah, that should be the presentation without the. Let me do it one other way then.
There you go. That's perfect. There you go.
Okay. No idea what I did, but good. Are you doing any editing before you post these up after that?
I might do a little bit, but you know what? People like to see the back what's going on. You're good. You have the floor, Mr. Yesner. You have the floor.
Cool. Thank you. So I appreciate it again.
You want questions during? You just want to wait till the very end for Q&A?
Why don't we wait till the very end? Because then I'm sure I'll have to figure out how to pull up the chat screen at some point to answer.
Oh, I'll do that for you when we get to the end. I'll hang around here for you.
Okay. So thanks again. Like Scott said, I am an attorney. I've been practicing now for, October will be 21 years. I've been in practice as an attorney. And so all of my career has been in real estate law, residential, commercial closings. I then went to what we would affectionately call a foreclosure mill. And so I was taking houses away from borrowers, did that for 3 years. And what I really appreciated about that opportunity is it gave me the whole spectrum. So I had everything that was going on within the foreclosure case, from picking the defendants, from arguing contested cases, bankruptcy cases, evictions, REOs, the whole 9 yards. I got the entire spectrum of a foreclosure from start to finish. After a few years there, that firm shut down. And so rather than moving laterally, I said, well, let me take what I know about how to do a foreclosure quickly and see if I can start representing homeowners and slowing these things down and helping people maybe save their houses. Well, of course, you can't do foreclosure defense without getting involved in the investor community. So that got me involved in the investor community, helping with LLCs and structuring deals and subject to transactions and seller financing transactions and wraparound mortgages and that whole 9 yards. And so that's what I've been doing now since 2004, has been representing homeowners in foreclosure, representing investors that want to buy property, representing note investors. I still do plaintiff's foreclosure from time to time, although I don't represent, the Chases and the Banks of America and all those kinds of places. I represent the seller financer guys, the people that probably most of the people who are going to be listening to this webinar, the seller financiers, the people that buy notes. Those are typically the people that I represent in a foreclosure lawsuit. But I still straddle both sides of the aisle, obviously not at the same time, but I still straddle both sides of the V here in the lawsuit. So what I thought I'd talk about today, the initial slide, legal solutions for non-performing notes. Thanks again, Scott, for having me. So I know we've got a little bit of time, so let me jump in. So first thing I wanted to talk about is, what is your goal? Do you want a performing note, or do you want the property? And when I was representing banks, we were always told, we don't want the property. Banks don't want to be property managers. They don't want to have to sell properties. They don't want to have to maintain properties. They don't want to have to worry about that. And even today, when I get a client that comes to me that says, well, obviously the bank wants my house because of the equity in the house. Well, no, they don't. Wells Fargo doesn't want your house because it may or may not have equity. Bank of America doesn't want your house. Deutsche Bank, Freddie Mac, they don't want your house. They want the stream of payments. And I have a feeling that many of the people that buy notes share a very similar concept, in that they don't necessarily want the property. They want a performing note. They want that stream of income. Now, at the same time, when we're dealing with an individual, I get it. And so if you hold the note on a piece of property that has a significant amount of equity, yeah, there may be a business decision where you say, I'm tired of dealing with this borrower. Give me the house. I'll sell it. I'll rent it out. I'll sell it to an investor buddy of mine that buys and sells these properties, whether we're talking about single family homes, 1 to 4 unit, multi-unit, commercial, whatever. The note investor may get to a point where they say, forget it. I'm tired of trying to fight for this stream of payments. So give me the property. So that may be a consideration here in dealing with a non-performing loan, is that you may end up wanting the property back. But let's start with, I want a performing note. Well, the easiest way to get a performing note is to modify the loan, is to work with the borrower to modify the loan. Now, this is the promissory note that I use. This is my form promissory note that I use for investors and anyone who wants to sign a note. And obviously, I can edit this or change it or whatever. And so when I'm talking about modifying the loan, a lot of times what I'll say to my clients is, well, the bank can do a bunch of stuff. They can drop the principal balance due. They can adjust the interest rate. They can adjust the terms. They can adjust the amortization. The bank can do all these different types of things. The question is, what will the bank do? And when you're dealing with a big bank, a Deutsche Bank, a Freddie Mac, a Bank of America, whatever, they have their box, they have their script, and they're not allowed to go beyond that. The frontline person, even you go 2-3 levels up at the bank at the 800 number, they still don't have the ability to think outside the box. And that's where you all, as the investors, as the note buyers, have that kind of flexibility. You have the ability to think outside the box. And in a lot of cases, I think you all do very good for the public by buying these loans, because you can think outside the box and modify them and leave the people in the house, or leave the building owner in charge, or whatever the situation might be. I think that is a really good service that you all can perform. So what are the things that we can do with a typical promissory note? Well, we can change the principal balance. Now, in my note, that's right there. It's also in the top left corner where it says the amount. You can change the principal balance. You can reduce the principal balance. You can say, I'm going to drop this principal balance. And we'll talk a little bit about why you might want to do that. But you can say, we're going to take the principal balance down from 200 to 150, something in that range. And there may be reasons why you would want to do it, especially if you bought that loan for 100 to reduce it from 250 to 150, you're still going to make $50,000 plus interest when that loan's repaid. So reducing the principal balance may not be an issue for you. The other thing you can do, you can change the interest rate. The interest rate is right there in my note, but it may be other places in other notes. Now, one thing I do want to back up a little bit. So this is the note that I use. You can see at the bottom it says documentary stamps in the amount required by Florida law have been affixed. And actually, I misspelled affixed, so I'll change that. Affixed to the original mortgage. I'm a Florida attorney. I'm licensed in Florida. I've tried to keep this presentation generic where I'm going over the general concepts and the general principles, but I am going to suggest that if you are not in Florida, find a local attorney. Find someone that knows the laws of the state where you're located. There are some things I'm going to get into that are Florida specific, and so then by analogy, you may want to go to your local attorney and say, how does this apply in our state? I tried to keep it very generic. I tried to keep it the 50,000 foot overview. I will dig into a little bit of quirks in Florida law so that you can analogize. So, again, you want to make sure that you're talking to a local attorney. If you're in Florida, definitely give me a buzz. I'm happy to talk to you. I'm happy to help you. I can work with anybody anywhere in the state of Florida. So you can change the interest rate. You can drop the interest rate down to whatever percent. If the loan was at 7 or 8%, you can drop it down to 3 or 4%. If it was at 10, 11%, you can drop it down to 7, 8%. You can do what you want with the interest rate. You can also change the number of payments, which is right there. So, maybe this was a 15-year loan and you can turn it into a 20-year loan. Maybe this was a 5-year loan. You can turn it into a 10-year loan. You can do something like that, and changing the number of payments and re-amortizing the loan, again, drops the payments, makes it more affordable, makes it more likely that the person's going to remain in the property and continue to make you payments. You can change the maturity date, which is right there. Now, I'm going to get into some other issues with maturity date, but what I'm talking about here is you can take a 30-year loan that is amortized over 30 years and make it a 40-year amortized loan and then balloon it at 30. You can extend it out. So maybe your borrower is 7 years in. Well, you can extend it back out for 30 years. So they were 7 years into a 30-year loan. They got 23 years left. You can re-amortize it and push it back out to 30 years. And so there are things you can do to change the maturity date, re-amortize the loan, which again will drop the payments, make it more likely that your borrower will be able to afford the property, stay in the property, continue making monthly payments. Now, that thing that I pointed out, the documentary stamp taxes, that is something that I think most states will have some type of documentary stamp tax structure. Basically, what that means is the transfer taxes, and there are also intangible taxes in Florida. So what you want to do is be careful. I know that in Florida, you may have to pay more in documentary stamp taxes. You may have to pay an additional documentary stamp tax or intangible tax if you are creating new value. But if you're extending the maturity date, if you're changing the interest rate, you're not necessarily creating new value. So there would be no continuing obligation to pay any additional transfer taxes by doing this loan modification. But if you're going to add principal balance to the loan, then you may want to take a look at, do I have any obligation to pay the additional transfer taxes, the additional documentary stamp taxes? What does your state require? The beauty of this analysis is that you can do any one or more of these things. So you can drop the principal balance and the interest rate and extend the loan out 40 years and balloon it at 30. You can do all kinds of different things. It's whatever, if you are the note holder, if you are the lender, so to speak, you can do whatever you want. The reason the banks don't do these is because there's TRID rules, there's RESPO rules, there's federal lending rules, there's all these things that they have to comply with. You may or may not need to comply with some of this stuff, whether it's commercial, whether it's residential, whether you buy the loan, again, double check. But where you can think outside the box, a lot of the banks can't. So, the loan modification is probably a really good way to help somebody keep the house affordable and stay in the house. So I would suggest that you look into that as a means of keeping people in their properties. But then what happens if the loan modification is unsuccessful, if the loan modification doesn't work, if the person can't afford the loan after the modification? There may be all kinds of reasons. And I think the loan modification is really only the practical means of changing the loan and keeping the loan if it's behind at the time you acquire it, if it's non-performing at the time you acquire it. So in that case, we then maybe have to bring the hammer down and see if we need to take the house back. And so we can do a deed in lieu of foreclosure, which I'm going to go into. We can do a short sale, which I'll get into, or then you pull the trigger and you do the foreclosure. And so those are the three things that we're going to talk about next, is how do those things work? And these are all options to take the property back. So a deed in lieu of foreclosure, and this is my definition. I don't know that there's any standard definition, and this is cobbled together from experience and from the internet, which we all know is always correct. So a deed in lieu of foreclosure is a voluntary conveyance of mortgaged property back to the mortgage company to satisfy the loan and avoid foreclosure proceedings. So a lot of people call it a deed in lieu. I've always called it a deed in lieu of foreclosure, because you are giving the property back in lieu of the bank foreclosing. So let's talk about some of the pros and cons. So one of the pros of a deed in lieu is that it's voluntary. This is not a fight with the homeowner. They're voluntarily giving you the house back. It's cheaper than foreclosing, and we're going to talk a lot about how and why that could be coming up. It's faster than foreclosing, and I'm going to get into judicial and non-judicial, and so we'll get into why it might be faster. It's less of a fight. Now, this kind of relates back to the voluntary issue, is that if they're doing a deed in lieu, if the property owner is doing a deed in lieu, this is all cooperative. This is all voluntary. It may start out as a fight, but then it's going to end up as a deed in lieu, and it's going to be a lot more voluntary. You can put conditions in the deed in lieu documents, like the homeowner or borrower or owner is going to leave the property in broom swept condition, meaning they're not going to take a sledgehammer to the walls. Those of you that are doing the residential stuff, they're not going to take the refrigerator. I've got a client right now who is really upset at the bank and wants to take the refrigerator, the stove, the air conditioner, the ceiling fans. He wants to take all that stuff on his way out. Now, theoretically, at least here in Florida, that's all personal property. And so you want to remove personal property. There's nothing that says legally you can or can't do that, as far as I know. He was worried about criminal prosecution, but it's his own stuff. So I don't think he can steal his stuff, his personal property. The worst case scenario in his case, in your case, is that there'd be additional damages or additional liability. But if he's facing a deficiency, what's more deficiency? That's really no threat to him. So that's what he's threatening. So having a voluntary deed in lieu, having a settlement with the borrower, making sure you put terms in there like they have to leave the house broom swept, all of that's going to help you to get back a cleaner property with less risk. I mean, I remember a story when I was foreclosing where the homeowner on his way out literally painted everything black. Literally black. The roof, the floor, the walls, the fixtures, the windows, everything was painted black. Well, you can put conditions in your deed in lieu that the homeowner won't do anything or the property owner won't do anything to impact the condition of the house. And if they do, the deed in lieu is invalid, and then you can go after and sue the homeowner for those damages, for the breach of those deed in lieu contracts. This next one really isn't a pro for you, but it may be a pro in terms of how to sell a borrower that they should do a deed in lieu. And my understanding is that the impact on credit is a lot better, is not as bad as a foreclosure. So a deed in lieu has a more of a better impact on credit, those of you that may be reporting to credit, than if it's a foreclosure or something like that. So what are some of the cons? Well, the biggest thing you've got to worry about, inferior liens stay. So what do I mean by inferior liens? Second mortgages, association liens, IRS liens. judgment liens, those kinds of things. If you voluntarily take back the house, take back the property, and it's got these liens on it, those liens are not eliminated in a deed in lieu. So you may be forced to be in a situation where you have to continue the foreclosure in order to eliminate those inferior liens, or you put a restriction on the borrower that the borrower has to satisfy those inferior liens before you do the deed in lieu. I mean, the last thing you want to do is be in first position, take back a property in a deed in lieu, and now you're having to deal with a second mortgage that is not eliminated because the property was conveyed. In essence, the borrower is violating the due on sale clause within that second mortgage lien by doing the deed in lieu with you. So you do want to make sure you're doing your due diligence. You do want to make sure you get a title search done. You want to make sure you know what inferior liens can be on the house. Now, I know at least here in Florida, property taxes are a superior lien. So property taxes would even trump a first mortgage. So if there's a situation where you've got a unpaid property taxes, again, you definitely want to do your due diligence. You definitely want to do your title search. You definitely want to see what is going to continue to impact the property after you take it back. Another con here for you all, like I said, do you want the stream of payments or do you want the house? Well, if you're the type of investor that wants the stream of payments and you don't want to deal with the house, well, deed in lieu, you're going to get the house back. So if that is a negative for you, that's why I put it here in the con, because it tends to go against the thought process of, I want my stream of payments. You're going to get the house back. Now, the good news there is you do a little bit of fix up, you can sell the house. You do a little bit of fix up, you can throw a tenant in there, or if it's a commercial building, whatever. So there are certain benefits to getting the house back. If you've bought the note right, you will have some equity and some profit built in there. So getting the house back may not be so bad. I also put impact on credit here as a con, and this is also a little bit more from the borrower perspective. So from my understanding, when we're dealing with the bigger banks, the Wells Fargos and the Bank of Americas and those guys, they continue to report payments, missed payments on credit after they've acquired the house by a deed in lieu until they sell the house. So if they acquire the house in a deed in lieu in January, but they end up selling the house in July, they're reporting the borrower as being late January, February, March, April, May, June, July. So you got all those missed payments, those negative payments continuing to hammer the credit of the homeowner. Not necessarily an impact for a con for you as the note holder, something you need to be aware of if you are reporting to credit agencies, and something you need to double check with your counsel to make sure that that's legitimate. I've always kind of felt that that's not legitimate, but there's some underlying legal issues there that may be impacted state to state on whether it's appropriate or not. So something you may want to definitely double check, but it may be a reason why your borrower does not want to do a deed in lieu because they're worried about the impact on their credit. And then the last con here, relocation assistance. And this goes back to being cheaper than foreclosing. So in Florida, we charge filing fees based on the value of the loan, based on the value of the note. So any note, I believe it's up to $50,000, is a $400 filing fee. If the value of the note is between $50 and $250, it's a $900 filing fee. If the value of the note is greater than $250, it's a $1,900 filing fee. Now, on top of that, you've got service of process. You've got the cost of the title search that you're going to do. You've got whatever other due diligence, drive-by inspections, whatever it is that you want to do, that you need to do. So if you're talking about a loan that's $300,000, and I don't think it matters residential or commercial. So if you're talking about a $300,000, $500,000, $1 million loan, whatever it may be, you're talking about a $1,900 filing fee plus costs. You're probably in excess of $2,000, $2,200, $2,500, something in that range, just in costs. And then I know for me, I charge anywhere around the $2,000 range in attorney's fees. I charge a flat fee basis, although I do switch it to hourly if I really get into a legal battle here. But just thinking about it that way, if I charge a $2,000 attorney fee and you got $2,500 in costs and filing fees, you're looking at a $4,500 nut just to file this foreclosure case. Well, maybe you offer the borrower $2,500 to get out of the house and do a deed in lieu. And in that case, you've saved yourself $2,000, or maybe you offer them $1,000 or $1,500. Or I've seen some banks that say, if you're out in 30 days, it's 2,000. I'm sorry, if you're out in 60 days. No, I apologize. I said it right the first time. If you're out in 30 days, it's $2,000. If you're out in 60 days, it's $1,000. If you're out in 90 days, it's $500. So borrower, you get to pick the amount of time that you're at that you need to get out of the house. But every time you bump that deadline, you get less money. You could structure it that way. Although I know that in a non-performing situation, speed is key. So, maybe you say $2,000 or $2,500 or $1,500 to get out within 30 days, and you've saved yourself from a $4,500 filing fee. Even if you paid me a couple of $100, $750, $1,000, whatever, to prepare and review the deed in lieu documents that the borrower is ultimately going to sign, you're still coming out cheaper than if you had filed the foreclosure to begin with. So, paying the homeowner to get out of the house, paying the property owner to leave you the property in the deed in lieu may not be a bad situation financially, maybe something that you want to evaluate financially. So let's move on to a short sale. And again, this is my sort of homegrown from experience definition. It's the sale of real estate for less than what is owed to the mortgage lender. And so a lot of you will say, well, wait a minute, if I bought a $250,000 loan, why would I take less than that? Well, let's take a look at the numbers. And again, 50,000 foot overview, very, very simple numbers here. So let's say that the house is worth $175,000 or the property. The amount owed is $250,000. So your note, regardless of what you buy it for, your note is worth $250,000. You need to be repaid $250,000. But you made a good deal here. You talked to us. You're one of Scott's students. You follow the note closers, and you bought the note for half. So you bought the note for $125,000. Well, look, if you allow the short sale for the value of the house, if you take $175,000, you still get a $50,000 return on your money. That's a 40% return. Now, again, 50,000 foot overview, so we're not including closing costs and all that other kind of stuff in here, but just basics. You made a $50,000 return on a $125,000 investment. You made a 40% return on your investment. Not really a bad deal. So there may be situations where you buy the note and then you allow the short sale, because the option here is you take back the house. You have to hold it. You have to carry it. You have to fix it. You then have to sell it for $175,000. So again, if your primary goal is, I want the stream of payments, I want the money, you may want to skip the deed in lieu altogether and just do the short sale, because you're not going to have to deal with the house and you're still going to get money back. Now, if you bought the note for 125 and the house is worth 100, then obviously a short sale is not necessarily the best idea. And neither would a deed in lieu potentially. But in most cases, if you buy the note right, the mentors in this space that I look up to, you don't make money when you buy the property, when you buy the note. You make your money, you do make your money when you buy the property, when you buy the note. You don't make your money when you sell it. So if you buy it right, a lot of these things could be really good things for you. So next, what I want to go into is foreclosure. So again, my definition, it's a legal process by which a lender forces the sale or liquidation of the house, of the asset, in order to repay the debt or the note in this case. So in talking to banks, they don't really want to foreclose, but they get backed into a corner. You may get backed into a corner where you feel like this is the only other option that I have. I have to foreclose. The borrower's rejected the deed in lieu. They can't sell the house. They're not giving me my money. The loan modification is never going to result in an affordable payment. Sorry, I got no other options. I need to foreclose. Now, before I get to that, I want to talk real quick about a mortgage versus an agreement for deed or a contract for deed, because I know a lot of the people in the note buying space love agreements for deed, love contracts for deed. Now, this is a Florida-specific issue that I'm going to get into, so definitely something that if you're not in Florida, you want to run by your legal counsel, you want to run by your team to see how agreements for deed are treated in your state. But in Florida, an agreement for deed, a contract for deed. Here's the definition straight out of Florida statute. And I gave you the site if you're a citation geek like me and you want the site. It's Florida Statute 697.01. So an instrument of writing, conveying or selling property, either real or personal, to secure the payment of money, shall. Now, those of you that are not attorneys, when you see the word shall in a statute, replace it with the word must. So must be deemed and held a mortgage, must be subject to the same rules of foreclosure and to the same regulations, restraints, and forms. So what Florida says is that an agreement for deed is a mortgage. Now, I know that what an agreement for deed or a contract for deed, so you're going to retain title to the house, or the seller is going to retain title to the house. And when the buyer completes the payments, then the seller is going to deed the house to the buyer at that point in time, like a car. You know, when I'm done making the car payments, I get the car title, kind of a thing. Florida says, sorry, that's a mortgage. So if you buy an agreement for deed or you buy a contract for deed in Florida and the payer, the buyer, falls behind, even though the seller still retains title to that property, you still have to foreclose, because Florida says that contract for deed, that agreement for deed, is a mortgage. So just be careful as you're buying and selling agreement for deeds. I know they're really popular amongst note investors. As you're buying and selling agreements for deed or contracts for deed, check with your local counsel, see how your state treats them. If you're in Florida, I can tell you it's a mortgage. It's got to be foreclosed. There's no other way around it by statute. So now that we've got that out of the way, the other thing I wanted to get out of the way, judicial and non-judicial states. Now, again, full disclosure, I found this on the internet. And as we know, everything on the internet is absolutely 100% true. So the grain of salt I'm going to give you here is, double check, double check that this map is right. And that's pretty easy by calling an attorney in that state and saying, hey, I'm looking at buying a note in Colorado. Hey, Mr. Colorado attorney, I understand you're a non-judicial state. Is that true? And they'll say yes or no. I do know for certain Florida is a judicial state, so I know that is correct. And I believe that this map is correct. But again, grain of salt, double check if you're buying notes in these places, double check with a local attorney to make sure it's true, that what I'm giving you here is true. However, what is the difference, judicial and non-judicial? And it is pretty much as simple as it seems. And I'll go back to that map here in a minute. But in a judicial foreclosure state, the foreclosure is a lawsuit. So a lot of times we'll describe these as lien theory states, meaning the homeowner owns the house, the lender has a lien on it. And so because these are lawsuits, we need to go in front of a judge. They tend to take longer. Compare that with a non-judicial state. This is where the foreclosure is based on documents, based on statutes. A trustee oversees it. A lot of times these are deed of trust states. So the bank holds title. It's a title theory state. The bank holds title, and when you get done paying off the loan, the bank will give the title to the homeowner. So it's a little bit easier. It's a little bit quicker. These actions are governed by contract and statute. Typically, they're a lot faster than a judicial foreclosure because the homeowner does not yet own the home until he or she, or does not own the property until he or she pays off that loan. So let me describe to you, some people say, why does it take so long to foreclose in Florida? So I'll pull up this map again so you guys can stare at this map while I describe a judicial foreclosure timeline. So at least here in Florida, once the borrower is served, and maybe it takes 20, 30 days to find and serve the borrower, but once the borrower is served, they then have 20 days by Florida rule to respond to the lawsuit. So if it takes 20 days to find the borrower, and then they have 20 days from the date they're served, you're already at 40 days right off the bat, a month and a half right off the bat. From there, an attorney like me may or may not get involved, and chances are one of the first things I'm going to do on the foreclosure defense side is I'm going to file a motion for extension of time. So before that 20 days to respond to the lawsuit is up, I'm going to file a motion and I'm going to request another 20 or 30 days so that I can gather all the necessary facts, gather all the evidence, try to figure out, are we going to do a short sale? Are we going to do a loan mod? Well, what's the plan here? But again, if I ask for another 20 to 30 days, now we're at day 60 or 70 before the foreclosure moves forward. Here in Florida, we are allowed to do a mortgage modification mediation. We're allowed to ask for mediation for the purpose of trying to modify the loan. Now, those of you that are listeners to the Crushing Debt podcast, those of you that are not, it's everywhere. So you can go to Apple Podcast, Stitcher, Spotify, all that stuff, shameless plug, and you can find the podcast. But there are episodes where I rail against the mortgage modification mediation process in Florida. As a defense attorney, I use it. I think I have to use it. But as an attorney in general, I hate it, because where you think a mediation is where one side starts with one viewpoint, the other side starts with another viewpoint, and the job of the mediator is to bring them to the middle. In a mortgage modification mediation, it's simply, do you qualify for a loan mod, yes or no? That's it. One time, I've done hundreds of mortgage modification mediations. One time, I've left the table with a signed agreement on a loan modification, and that was where there was a credit union on the other side. I have a feeling if it were one of you that held the note on the other side, we probably would be able to hammer something out at the mediation table. And again, I'm representing a client right now where the borrower has requested a mortgage modification mediation, and we should be able to get something hammered out at the table because it's us. But when you're dealing with the big banks, the Bank of Americas and Wells, and you can tell those are two that I tend to hold dearly, they don't have the opportunity to, again, think outside the box, think creatively, and make deals on the fly. It's basically they're governed by federal banking rules, and they have their criteria of what they can or cannot offer. And I don't think I've ever been offered a loan modification at the table when dealing with one of those so-called big box banks. But again, that mortgage modification mediation process, you're talking about adding another 60, 90, 120 days to the process, because you file the motion gets granted. The motion says you have to mediate within 30 to 60 days. You have to submit all your documents. You have to get time with the mediator. You have to get all that scheduled. So again, just doing the mortgage modification adds 60 to 90 days to the process. Now, let's say the modification does not result or the mediation rather does not result in a modification. So the foreclosure then proceeds. Well, at that point, the bank is going to file here in Florida something called a motion for summary judgment, or as I describe it, a motion for final judgment. Now, that motion, you have to have all your evidence filed at least 20, 25 days prior to the hearing. So that adds another 30 days to the process, depending on how long it takes the attorney to draft all that stuff. And even though these are all forms, we do have to be a little fact-specific case to case. So it does take a little bit of time to draft the forms, draft the affidavits, get all that stuff signed, get all that stuff filed. But now you're talking about how long is it going to take to get hearing time in front of the judge. As we give this presentation, it's July. I just scheduled a October hearing in front of the judge. 3 months to get a hearing, to get 15 minutes in front of the judge. And that's just based on the judge's calendar. And so you finally go to that summary judgment hearing. Now, if it's a good foreclosure defense attorney and the facts are right, we're going to file our counter affidavits to say the bank is not entitled to its judgment. Now, here's the thing. If the bank wins at the summary judgment hearing, that means the judge bangs the gavel, bank wins, we're going to set a foreclosure sale. If the bank loses its summary judgment, then typically all that means is that the bank doesn't win and the case proceeds forward. But again, it's another way to delay. If I can insert some factual issue or some legal issue that says why the bank should not foreclose, it's another way to delay. So then the next thing that happens is the bank schedules a trial. Well, if it takes 2 to 3 months to get 15 minutes in front of the judge, imagine how long it takes to get a trial in front of the judge. And these are legit trials, opening statements, closing statements, examination of witnesses. Florida says they are not in front of a jury. The foreclosure piece is not in front of a jury, and I think that's because the Florida legislature doesn't want people to have to decide to take away someone else's house. So these are all judge cases, but still, the amount of time it takes to get some trial time, a half-day trial even in front of a judge, can be pretty significant. So as we go, and then when we get to that final hearing, when we get to that trial, when I see as the defense attorney that it is likely judgment's going to get entered and a sale date's going to get set, I'll then ask the judge to give me 90 days between the date of the hearing and the date of the sale, 120 days, 150 days. Typically, they'll give me 60, 90. Sometimes they'll give me 120. But again, that's adding another 2 to 4 months from the date of the hearing before there's a sale. So if I really did this right and I really fought tooth and nail, I could probably extend a foreclosure out a couple of years in Florida. And some of that's due to the motions that I file. Some of that's due to the legal processes. Some of it's due to the timelines inherent in the process. Some of it's due to the amount of time it takes to get in front of a judge. Some of that's due in terms of the time it takes to get in front of the judge for a hearing, for a trial. And so that's why judicial foreclosure states take so long to get the foreclosure done. Now, we're going to get into some of these defenses and some of these other things in a little bit, and I'll describe some of that stuff to you. But that's the reason why it takes so long in a judicial foreclosure state versus a non-judicial foreclosure state. So the next thing that I wanted to talk about is, okay, now you've decided it's time to foreclose. Well, what are some things you should be thinking about? Well, you need to have the original note. If you don't have the original note, you're pretty much sunk before you start. Now, again, Florida has a process where you can do what's called reestablish the note. You can reestablish if you know the terms of the note. You can also prove that you paid the money to buy it from the person that held it. And so you can prove you own the original note that way. But your life will be a lot easier if you have that original note. Original mortgage, I'm not so strict on as I am on the original note, and at least because the original mortgage should be recorded. And so I would assume in every state, you can go to the county records, you can have the clerk of the court certify a copy of the mortgage. So the clerk of the court certifies that, yes, this is the mortgage, the original mortgage that was filed with the clerk of court office, with the county records. And so if you get that certified mortgage, certified recorded mortgage, you may not need the original. But as a best practice, if you're going to buy a loan, make sure they got the original note, make sure they got the original mortgage. Allonges. Hopefully you all know what an allonge is. I would make a joke, put it in the comments, tell me. But no, an allonge is an endorsement. So, the way that I describe it a lot of times to clients is you think about a check and I sign it over to Scott and Scott signs it over to Mary and Mary signs it over to Fred and Fred signs it over to this one and this one signs it over to that one. Well, eventually you're going to run out of room to sign on that check. So you take a piece of paper, you label it endorsement, and you start signing it. As long as that piece of paper is now attached to the check, it's an allonge and it is valid as an endorsement of the check. Same thing with a note. So Bank of America will assign it to Wells Fargo. Wells Fargo will assign it to Regions. Regions will assign it to this one that assigns it to that one. Typically, they don't sign the original note. They just take a piece of paper, they label it an allonge, they sign that, they staple it to the note. That's good enough. Now, at least I know in Florida law, it's got to be attached. So a lot of times that means stapled, although if the bank has all the allonges, I don't know that I really am going to gain much favor with the judge by arguing that it wasn't stapled, as long as they have them all. Similar to the mortgage, so the allonge is what endorses and transfers the note. The assignment is what transfers the mortgage. So not only do you want to make sure you have all the recorded assignments, you want to make sure that the assignments and the allonges follow. So if the note was originated with Wells Fargo and then transferred to Bank of America, you need an allonge signed by Wells Fargo transferring to Bank of America, and you need an assignment from Wells Fargo to Bank of America. So you want to make sure that your allonges and your recorded assignments all follow the same paper trail. There's issues here with MERS, which I think may be a little bit beyond this presentation in terms of what MERS is and how that works. Mortgage Electronic Registration Systems, MERS. If any of you have questions about that, my contact information will be here at the end. I'm sure you can find me on social media. Shoot me an email and we can get into a little bit more of a discussion, or maybe I can talk with Scott about doing a little bit more in-depth discussion on MERS itself. But basically, MERS is a holding place for recorded documents so that you don't necessarily need the assignments, but you still do need the allonges. But again, check that you've got the allonges, check that you've got the assignments, check to make sure that they all follow the same trail. If the note is non-performing, if it's behind, you want to know what demand letters or what notices the former owner sent to the property owner. You want to make sure, because there are certain requirements within the loan documents on what types of letters and notices need to be sent. So have those been sent? Do you need to send them? Were they sent correctly? All those different types of issues. What's the principal balance do? Were there modifications in the past? how much is due, even though you bought it, like I said in my previous example, even though you bought it for 175, a lot of borrowers will say to me, well, the bank bought it for 175. Well, how come I don't have to pay that? I say, well, because you signed a contract that you would pay back 250. So that's what you got to pay back. But you got to understand that the amount you pay for the loan isn't necessarily the principal balance due. So what does the document say is the principal balance due? What's your default date? When did the borrower breach this obligation? And I'm not necessarily talking about just a payment default. There could be other breaches there. What were the dates of those breaches? You want to have your title search. Who are my defendants? What other issues are out there? Similar to a deed in lieu. What kind of situations am I facing? You want to know the reason for the default. So is this a payment default, which is probably going to be 99% of your cases? Is it a due on sale default? I typically tell clients that when you're dealing with the big banks, yes, a due on sale default where the homeowner sells the property to somebody else without permission of the bank. A due on sale default is a default. The bank can call the loan due, but I don't know that they're necessarily monitoring all this stuff. Well, depending on the size of your organization, the size of your team, you may have the ability to search this kind of stuff. And if you see that the borrower is no longer the owner, you could declare the note due for a violation of the due on sale default. Interestingly, I had a mortgage foreclosure case within the last year where the reason for the default was that it was a commercial loan, and the borrower lied on his mortgage application, falsified bank records to get allegedly falsified bank records to get the loan. And the bank called the loan due because of the misrepresentation and dishonesty within the loan application itself. The payments were current, but the bank said, you lied on the loan application, we're calling the loan due. And they filed it in federal court, not state court. So it was a pretty interesting case. I got, I won't tell you that I got steamrolled, but it was not easy. The borrower ended up selling the house to pay off the loan. Are there late charges? And what are the late charges? And how many late charges? And what other charges? Property inspections, what other kinds of things, what other kinds of expenses are due in connection with this loan? Is the house insured? The last thing that you want to have happen is try to foreclose, try to get the house back, deed in lieu, whatever, and the house burns down accidentally, intentionally, whatever. The last thing that you want to have happen, or as we record this here in July, we're at the beginning of hurricane season. The last thing you want to be concerned about is trying to foreclose on this loan and a hurricane comes through and blows the house away, or wherever you live. Maybe the house is in Pasco County, which is the Newport Richey area, which is Swiss cheese, and maybe the house is swallowed by a sinkhole. So you want to make sure that you've got, that the loan has whatever insurance it needs. If not, talk to your property and casualty agent. You can buy insurance that's force-placed or lender-placed insurance if the borrower fails to do so. Are the property taxes paid? Again, that'll be part of your due diligence. Property taxes are superior, at least in Florida, and I would assume in most other places. Uncle Sam is superior to a private first mortgage. And so if the taxes are not paid, you may want to consider paying those taxes to prevent the tax deed sale and preserve the equity in that asset. So those are just some of the basic preliminary considerations. We've decided to foreclose. What should we be concerned about? The next thing I want to talk about after I take a quick drink, commercial versus residential. So, I've been interspersing when I can property owner, homeowner, building owner, whatever. There is a significant difference between commercial and residential. A lot of the defenses that will fly in residential won't fly in commercial. A lot of the things that we do in residential foreclosure cases won't work in commercial cases. But in commercial cases, you guys have two very good levers. One is called assignment of rents. An assignment of rents is a contract. Now, sometimes this can be contained in the mortgage. In a lot of commercial cases, it is its own document. And what the assignment of rent says is that if you, borrower, don't pay the lender rent, the lender has the right to go to your tenants and have the tenants pay the lender the rent directly. So again, what do you want? Do you want the stream of payments? Do you want the property? If you're interested in the stream of payments and the borrower's not paying, you can go, if you have this assignment of rents provision, you can go to the tenants and say, pay me the rents. Now that does two things. That revives that stream of income that you want, number one, but it really squeezes the property owner, because typically the property owner is using the rents to fund the foreclosure defense, or they're using the rents to pay down debt other places, or they're using the rents to buy properties other places. So you're basically cutting off their stream of revenue, and you're diverting it to yourself, which is what the assignment of rents is designed to do. So it's a huge piece of leverage in a commercial situation. I do believe that there are assignment of rents provisions in a lot of residential loans. So look for those as well. But if they're there, it's something you file in the court, and then the court will allow you to do it. And then you go to the tenants and say, hey, here's the court order, start sending your rents to me. Depending on the language in the contract, sometimes you may or may not need to go to court to do it. Similar to the assignment of rents is something called a receivership. Receivership is a little bit more than pay me the rents. A receivership is the court actually appoints somebody to go in and run the building in lieu of the owner. And so that receiver is responsible to then collect rents, pay the mortgage, handle landlord-tenant issues. They basically step in the shoes of the property owner to control the property. So again, a receivership in essence cuts off the flow of rent to fund whatever the borrower, whatever the property owner is going to be doing, and it'll divert that potentially over to you as the note holder, and as well as maintaining the property and collecting rents and all that other kind of stuff. So assignment of rents and receivership are two huge tools that you will have as a commercial note holder, possibly as a residential note holder, to put some pressure on the borrower to, let's get this issue straightened out. Let's get this situation straightened out. So let's talk about some defenses that the borrower might have. One of the popular defenses is standing. In other words, who owns the loan? That's why it's so important to have the note, the mortgage, the allonge, the assignment, because then you eliminate this standing argument. You can say, I bought it from so-and-so. Here's the documents that prove I own this loan. Plus I've got the original note. Plus I've got the original mortgage. Plus I've got the allonges. Plus I've got the assignments. It's clear I own the loan. Take your standing defense and shove it. Another one is what I call the paragraph 22. Now, this could be a Florida specific issue, but I know in the general Freddie Mac residential mortgage form, paragraph 22 is the paragraph that governs the type of notice that has to be given to the borrower before the foreclosure can proceed. And what a lot of foreclosure defense attorneys noticed is that the banks got lazy in sending out their notices of default and acceleration, and those notices didn't comply with the mortgage document, with the mortgage contract, specifically paragraph 22. If you have a standard Freddie Mac mortgage, go ahead and go ahead and pull it. Probably also Google paragraph 22 and it'll come up. I'm not sure if this is a Florida specific issue or if this is in all of Freddie Mac's standard mortgages, but basically it is an argument that, hey, bank, you didn't properly comply with the contract when you gave us this required prerequisite to foreclosing. And so you want to make sure that's why I said whatever notices have been sent out, you want to make sure those notices are proper. Robo-signing, I wanted to bring it in just because it was fun. Those of you that don't remember what robo-signing was, the foreclosure defense attorneys would interview these people that would sign the affidavits that would support the foreclosure lawsuits. And what they learned was it was impossible that these people were signing as many documents as they were signing. It was something like, in order to sign the amount of affidavits that you say you signed, you would have to work 10-hour days. You'd have to walk into the office, clock in, start signing, take no breaks, no bathroom breaks, no lunch breaks, no water cooler breaks, no breaks to even take a sip of water like I did a minute ago. You would literally have to sign straight for 10 hours, no breaks, clock out, go home. It's physically impossible. And so that's what we call robo-signing. Now, interestingly, even as a foreclosure defense attorney, I always said that robo-signing was more the authenticity of the evidence or the admissibility of the evidence. Robo-signing didn't really impact whether the borrower had or had not made payments. It just impacted the reliability of the evidence that the borrower did not make payments. So, again, these were some of the more popular defenses. I don't know that they're around very much anymore. Standing maybe, But, paragraph 22, I doubt you'd see very often anymore. Robo-signing, I doubt you'd see any often anymore. The last one, unclean hands. Now, in a lot of foreclosure judicial states, we say that foreclosure is an equitable remedy, meaning there has to be some measure of fairness. Now, again, borrower didn't make payments, you're entitled to foreclose. But there has to be some level of fairness. So this is the way the unclean hands argument works. And I haven't yet had the opportunity to take this one all the way to the mat, so we'll see. But the way that the unclean hands argument works is the borrower called the bank and said, hey, I'm current, but I see the cliff coming. The bank says, I'm sorry, we can't help you unless you're behind. The borrower says, so you're telling me I need to fall behind? The bank says, we cannot help you unless you're behind. Borrower says, okay, you're not going to get my next couple of months' payments. The bank then forecloses and doesn't offer a modification. And so the borrower says, well, wait a minute. Bank, you told me to fall behind. You've come before this court, bank, with unclean hands. You've not been fair in your treatment of me, and therefore you should not be entitled to a foreclosure. Now, I think at the end of the day, borrower didn't make payments. The judge is probably ultimately going to rule for the bank, if the borrower didn't make payments. But I think unclean hands is as good a defense as any to say, you didn't do, bank, what you were supposed to do, so you're not entitled to foreclose. The next two defenses I want to get into are, one is Florida specific, one is specific to Florida, Georgia, Alabama. So I'll explain both. The first one is this Bartram case. This was a pretty big case here in Florida. And again, for you site geeks, there's the site. Like I'm a citation geek. There's the site. So this is a Florida Supreme Court case from 2016. This deals with statute of limitations. So this was a pretty big case here in Florida. Basically what happened was there were two foreclosures. U.S. Bank filed a foreclosure against Bartram. It ended up getting dismissed. I don't recall the reason. It ended up getting dismissed for some reason. U.S. Bank waited a little bit and then filed a second foreclosure case. Now, the statute of limitations in Florida is 5 years. The problem is the default was more than 5 years ago. And so the defense attorneys argued, wait a minute, you're beyond the statute of limitations. The default date is more than 5 years ago. Well, there's a second way. What the Florida Supreme Court said, there's a second way to analyze statute of limitations. Statute of limitations says you have to sue within 5 years of the end of the loan. And in the Bartram case, the maturity date of the loan had not yet come and gone. The loan was still due. It was due, the due date was whatever, 20 years out, whatever it was. And so we weren't beyond the due date, the ultimate end maturity date, due date of the loan. The court then said each default, each month is its own separate default. So you don't pay in January, that's January's default. You don't pay in February, that's February's default. You don't pay in March, that's March's default. And so what the court sort of split it and said, well, listen, bank, if you're going after payments that are more than 5 years old, you're not entitled to those payments. The statute of limitations to collect payments more than 5 years old has run. But you can collect payments that are due within the previous 5 years, and you can foreclose on the loan as long as the maturity date were not beyond the statute of limitations of the maturity date. So this case was a big win for the lenders. It did impact the statute of limitations arguments that a lot of borrowers brought. And so this is a good case if you're in Florida and your predecessor has been kind of lazy in collecting. This could potentially be a very good case for you. The other really good case for note buyers is this Fela, and I don't know if I'm pronouncing it right, Fela versus Citibank. Now, this is, you will notice in the site, an 11th Circuit case. This case deals with the surrender of a house in bankruptcy. And so bankruptcy is federal law. Foreclosure is state law. And so what happened in this case was the Felas were in foreclosure, and they fought, and then decided we need to file bankruptcy. They filed bankruptcy. In bankruptcy, they said, we are surrendering our house. And so the bankruptcy ran its course. The bank got permission to go back to state court and finish the foreclosure. And when the bank went back to state court to finish the foreclosure, the Felas started fighting again in state court. And so the bank said, well, wait a minute, that's not fair. You can't go into federal court, into bankruptcy court, and say you're going to give up your house, and then go into state court and fight me on it. And the bankruptcy court said, you're right. And it went up to the 11th Circuit. Now, the 11th Circuit is the appellate court that sits in Atlanta, Georgia, and governs Georgia, Alabama, and Florida. So this case law would be binding in any foreclosure in Florida, Georgia, and Alabama. And basically what the bank said is, if you surrender your house in bankruptcy, what the court said, sorry, if you surrender your house in bankruptcy, you're not allowed to fight the foreclosure. So don't necessarily be scared of notes that are non-performing that have come out of a bankruptcy. If they surrendered the house, and we'll get into bankruptcy as the next topic. If the borrowers have filed a bankruptcy and surrendered the house, they may not be able to fight you in a foreclosure situation. That may be a tremendous opportunity to modify the loan in such a way that you make it performing, knowing that they may not be able to fight you in bankruptcy. Now, there are some issues as to whether the modification impacts the discharge and can you modify a loan after discharge? We can get into some of those issues because our next topic is the wonderful world of bankruptcy. So we're going to talk about 7s versus 13s. I don't know that I have time to get into 11s, but I have experience with 11s. Basically, 7 is a liquidation, 13 is a reorganization, 11 is a business reorganization, or a reorganization for someone who doesn't qualify for 7 or 13. But I think I'm mostly going to focus on 7 and 13. Again, if you want more on Chapter 11, then give me a good review with Scott, and we'll see if we can get a Chapter 11 discussion going here. So, Chapter 7. The 2 questions you want to ask yourself: is the loan current? Because that'll impact what you decide to do as the note holder. And is the house homestead? Especially in Florida, that's going to impact what you want to do with the house. So a Chapter 7 is used to give up or surrender the house unless the loan is current. And the reason is because if you go into a Chapter 7 and you're behind on the loan holder, the mortgage holder, has the right to say, you got to catch up the loan if you want to keep the house. Well, if you're filing Chapter 7, you don't have the money to catch up the loan. So typically Chapter 7 is used to give up or surrender the house. Now, you could file a Chapter 7 and be current on your house. This also applies to cars and other secured debt. If the reason for your 7 is to get rid of medical debt, IRS debt, some student loan debt, again, talk to Scott about whether you want me to do a student loan thing, credit cards, other debts, you could use the 7 to get rid of that stuff to make the house more affordable. But as the note holder, what you want to look at is the statement of intentions. What does the debtor intend to do with this house? Are they going to redeem it? Are they going to pay you off in full? Are they going to reaffirm it? So Chapter 7 gives borrowers the opportunity to say, I'm going to reaffirm. I'm going to pull this note out of the bankruptcy. I'm going to continue to agree to pay and be liable for deficiency, even though this loan was in bankruptcy. That's basically what a reaffirmation is. Or surrender. I talked about surrender a couple slides ago in terms of we're giving up the house. Now, again, is the house homestead? What state are you in? Because Florida homestead is totally protected. So what state are you in? And how does homestead factor into that analysis? Or is it commercial property, in which case homestead doesn't matter? And then again, is the loan current? Are they going to surrender it? Are they going to keep it? What are they going to do with the house? But the thing you want to look for is a document, a schedule. A bankruptcy petition is about 50 pages. A small one is about 50 pages. The one you want to look for is called Statement of Intentions, and see what the borrower's intention is with the house. Next, I want to talk a little bit about Chapter 13. Again, same 2 questions. Is the loan current, and is the house homestead? Because that's going to impact your decision as the note holder. Typically, Chapter 13s are used to save the house, either through the plan or, again, loan modification. So most Chapter 13 trustees will monitor a loan modification process. So another way in foreclosure defense world, we go through the loan modification in state court. We don't get a loan modification. We file a Chapter 13. We go through a loan modification mediation again in the Chapter 13. Or the borrowers can put in their bankruptcy plan that they're going to catch up the arrears to save the house. And so over the 60-month, 5-year life of the plan, you're going to get not only the mortgage payment, but you're going to get 1/60th of the arrears. And then at the end of that 60-month term, that 5-year term, the loan will be current. And so Chapter 13 could be good for you as a note investor, because it means the borrower is going to try to repay the house. But again, what you want to do is look at the Chapter 13 plan. There is no statement of intention in a Chapter 7 in a Chapter 13. There is no document called a statement of intention. So what you want to do is look at the plan. And the plan's going to tell you the borrower is going to try to modify the loan. The borrower is going to pay back the arrears over the life of the plan. The borrower, maybe the loan is current and the borrower is going to pay the mortgage outside of the bankruptcy plan. You're going to get payments directly by the borrower and not from the trustee. And that has certain obligations and certain restrictions. Or again, you can use a Chapter 13 and surrender the house. And I'm going to give up the house. You can do that as well. Now, you want to make sure, again, even though bankruptcy is federal law, it's all governed by what the state exemptions are. So you want to talk to a bankruptcy attorney in your area, in your state, if one of your borrowers files bankruptcy. But the place to start would be the bankruptcy attorney is going to know that you know what you're talking about. If you say, hey, what does the Chapter 13 plan say? Or if you say, hey, what's in the statement of intentions? Are they going to reaffirm or surrender? The bankruptcy attorney should be impressed, or bankruptcy attorney is going to think that you're an internet lawyer. One of the two. The last thing I want to talk about here is a lien strip. And this is for those of you that buy second position notes. Basically, a lien strip is the process by which the debtor can eliminate a wholly unsecured recorded lien against the house. Now, you can't strip a lien for a first mortgage, but maybe second mortgages, judgment liens, association liens. Basically, it goes like this. The first mortgage is worth $175. The house is worth $150. So that first mortgage eats up every penny of equity. We got a $50,000 second mortgage. We can use this lien strip concept to eliminate that second mortgage completely, turn it into a solely unsecured debt, and then you as the creditor get paid whatever percentage the unsecured creditors are getting paid. Your second mortgage ceases to be a lien against the house, becomes unsecured debt, and if the unsecured creditors are getting paid 10 cents on the dollar, so are you. Again, this doesn't apply to first mortgages, but it could apply to seconds, judgment liens, and association liens. So that is the end of my presentation. There is my contact information, Shawn at Yesner Law. The website is also yesnerlaw.com. The website also has links to the podcast, which there's the logo for the podcast, Crushing Debt. That is also the cover of the book, too. The book's available on Amazon and everywhere else. So I appreciate your time. Thank you for listening. I think I see that we got some questions. So, Scott.
Yeah, we sure do. You're good. Don't be running off yet. We got a couple minutes left. So
yep.
Let's see here. All right, going back here. Jack DeWeese. Oh, hang on here. Jack asked a question. Do the HOPA and RESPA rules apply to single-family rental houses?
So I know that at least here, the intent is, what did you buy it as? So if you bought it as a primary residence and then you've converted it to a rental unit, then yes, definitely those laws would apply. I think the laws do not apply if it's a commercial situation.
That's correct. Yeah.
So you're buying office buildings, you're buying, vacant land, you're buying that kind of stuff. No, they don't apply. The question I think asks, well, what if it's in the middle? What if I'm buying a single family home? I think I would rely on your mortgage originator. Get a good mortgage originator on your team. Get a good attorney on the team. I think it might apply if it's a residential property, or at least being conservative. It might apply if you're going to buy it and rent it out. Then, yeah, you may want to worry about those issues.
Yep, exactly. Christina Fuller says, I'm not sure I caught it right, but does that assignment of rents provision need to be already in place, or is that another document that can be created when you're not getting payments from the borrower? It's going to be in place already. It's usually part of the actual mortgage, Christina.
Yeah, it's typically part of the origination documents, and it'll either be contained in the mortgage. Excuse me. It'll either be contained in the mortgage, or it'll be a separate document signed at closing. I guess you could, but if I'm the borrower's attorney, I'm never going to tell them to sign that if they're in the middle of a foreclosure.
Yeah, it's almost common in every commercial mortgage that we have seen. We have used this several times, especially on apartments and some mixed-use stuff where I bought the note, borrower filed bankruptcy, and then the judge assigned us, the bank, as receiver. So we were basically able to go in and start collecting the rents immediately, 8 to 10 months before we ever finished the foreclosure process. So once we were able to get that provision enforced, it really takes the wind out of the borrower's sails for not working with you. It becomes much more in their interest to work with you versus drag it all out.
Yeah.
Let's see here. Christine asks, how often do those claiming Chapter 13 actually end up not completing the plan? And how long does it take to know whether a given borrower is going to be serious with their payments? Would we want to see the BK13 performing?
So I'm gonna plug the podcast again. You can either go to the Yesner Law website or you can go to the whatever search for the podcast. I did an episode. It was called Chapter 13, Dead on Arrival.
I love that episode. That's a good one, Shawn. Yeah.
And yeah, the success rates in Chapter 13s are pretty low. I think what I saw in the study was like 50%, 55%.
Yeah.
And then the podcast was a whole analysis of, well, what if it's the first filing? What if it's the second filing? What if it's a husband and wife? What if it's a this? What if it's a that? 13s are only available for individuals. So if this is a truly commercial situation where the borrower is an LLC, it's going to be a Chapter 11, which has different rules. But you can look and see the trustees are pretty good about if the borrowers fall more than 30 days behind, they're going to file a motion to dismiss. So if you see motions to dismiss on the docket, there's also ways that you can search with the different trustees as to whether the borrowers are current in payments. That's going to take a little bit of time to get into. Plus, you're going to need Social Security numbers and all that stuff. But your bankruptcy attorney may know how to find out that information to see, it's been pending for 1 year and the borrower's current on payments or, whatever that is, or behind or whatever.
Exactly. Mary Ann asked the question on a short sale. Isn't that technically a loss to the note holder? Is that something that we have to then report to the IRS at some point?
I would say to talk to your CPA about that. Right. Yes. I mean, I think that's one of the advantages. So in my example, if the note balance is $250 and you take $175, even though in my example, you made a $50,000 profit, I think you could potentially report that $75,000 loss. Now, I don't know what's capital gains, what's capital loss, what's ordinary, that I don't know. So I would suggest you talk to a CPA. But yeah, I think that's why the banks are willing to do a short sale, because there is some tax benefit to them to take a loss. But, I graduated with a degree in accounting that qualifies me to run a calculator. I'm not a CPA.
So a couple of things you should, when you do a short sale, you have the right to send a, Form 1099.
1099-C, forgiveness of debt income, right.
Exactly, to the borrower. Now, whether or not, look at it this way, Marianne, if you bought that mortgage for if a $250,000 mortgage, you paid $100 for it, and you let the borrower walk at $175, yeah, it's a loss of that, but you really made a profit on that. So you got to be careful about that, because you it's not really a loss now if you're the originating bank, that's a true big loss. But if you're not the originating bank and you bought that note at a discount, you got to be careful about that. You can get a lot of trouble for doing that. But yeah, you should have to file a 1099-C. The borrower may not have to pay taxes on it. They can file an IRS form 928 that shows insolvency.
I think you flipped it. 982. I think
that's it. 982. Thank you, sir.
You got all the numbers in there, just in the wrong order.
But if they file that just shows basically they have more going out than coming in. They won't be paying taxes on that.
And bankruptcy. So borrowers that declare bankruptcy can use 982 to the form 982 to eliminate 1099. Basically, forgiveness of debt is you owed it. You don't have to pay it. You got a benefit, and whenever you get a benefit, Uncle Sam wants his cut.
Mm-hmm. Marlene, I'm not sure what you mean by how homestead plays out. What do you mean by that question?
The homestead's going to be one of those issues that you have to double check with a local attorney. In Florida, homestead is exempt. Yep. And so I can protect my homestead fully. It doesn't matter if I've got $1 of equity, $100,000 of equity, $1 million of equity. I can protect my homestead in Florida. There are other states where homestead is not exempt, or the exemption's limited. So if you were to file a Chapter 7 in Florida and you had equity in your house and you were filing Chapter 7 to get rid of your medical debts and your credit card debts, as long as you continue paying for the house, you get to keep the house.
Yeah.
So as the note holder, I'm not worried about that. But in another state where maybe the homestead exemption is limited, I think in California it's limited, I think in Georgia it's limited. Let's say you got $100,000 of equity in your house and you're in a state where the exemption's limited to $20,000. Well, what that means is that the trustee now has an $80,000 equity asset that he or she can liquidate to pay off creditors. And so if you're the note holder on that house, frankly, I don't know how all of that interplays because Florida's unlimited exemption, but you should go to an attorney in your state to say, hey, look, this house is worth $100,000. There's only a $20,000 exemption, for example, in our state. I hold a loan for 75. What happens when, I would assume that if the trustee says, I want the 80 grand of equity, you're going to get 75 of that as the note holder. And then the trustee is going to have 5 grand to pay to the other unsecured creditors. But again, double check with a local attorney. I don't know the specific answer.
Shawn, as always, brother, delivering such amazing content. People say, man, people have heard this stuff before, but never heard it so concisely in such an organized fashion. So once again, thanks, man, for just showing up and delivering as you always do, brother.
Thank you. I appreciate the invitation.
Anytime. Once again, guys, check out yesnerlaw.com. If you're there in Florida, like Shawn says, he's practicing there in Florida, other areas. You have attorneys in other parts of the country that if somebody is reaching out for somebody that somebody you'd recommend in different states, you have relationships with anybody? Or
I do belong to different organizations where, I can find attorneys in other states. Yes. I don't know that I have, this one in Georgia and this one in California and this one here and this one there, but I am in organizations where I can reach out and find people. Yes.
Awesome. And Shawn, you do a great job, like not only presenting, but also in the local Florida community. I mean, Tyler, Chef and I are all good friends, and you also do a great job with the podcast too. You're doing some amazing stuff with the Crushing Debt podcast. You guys should listen to it. Great stuff on there.
Thank you.
Thanks. All right, guys. So that's going to wrap it up for session number 1 of Saturday here. So what we're going to do is take a quick 15-minute break, let you run, grab a cup of coffee, water, bathroom break, what do you need to do? And we'll be back right at 11 o'clock with our next guest, Chuck Sutherland. So we'll see you guys back in 15.